Appearances, please. Who's here?
Quashante Short, QASHONTAE
Richard Jordan.
Again. And, you have not, I'm looking here, what is it? Intentional infliction of emotional distress?
Yes.
Is that the claim here?
Yes,
Okay.
It is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court.
That's an equitable action, yes. Mm-hmm.
I thought only criminal offenses. Well, I guess it would be considered. I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before.
Not get into what's in your head, man. Mr. Jordan, let me just ask you this: are you planning to represent yourself on this?
I to be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000.
Welcome back to the channel where courtroom chaos meets real life lessons. Today's case might just redefine emotional damage. We're diving into Quant Short versus Richard Jordan, a lawsuit so bizarre it feels scripted, but it's 100% real. A woman is suing a man for $10,000 over a single date. That's right, one dinner, one night, and apparently a lifetime of trauma. The judge is about to dissect his claim, but what unfolds next turns from awkward to downright unbelievable. Who's right here? A scorned plaintiff seeking justice, or a confused defendant caught in legal overkill? Buckle up, this one gets messy.
If you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it. The document in front of
the short. Perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of God. I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, mm-hmm. That is a criminal felony charge. You have to go through the prosecuting attorney and the police. Okay? So that's what you are alleging.
Yes, the document will show that, and I've also sent forth the messages where he was lying.
So here's where things go off the rails. The judge calmly explains that emotional distress lawsuits can't even be handled in district court. They belong in circuit court. But instead of taking the hint, Quant digs in. And this isn't her first rodeo. She's filed lawsuits worth millions before, against police departments, companies, even individuals. It's a pattern of overreach, and the judge knows it. But the real kicker? She's suing for emotional pain from a single date. The irony is thick. You can practically feel Richard trying to process how dinner turned into a $10,000 problem.
It could have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see that mentioned in your complaint.
Yes, I emailed that.
Did you amend your complaint?
I didn't have to amend my complaint. I had to get an address for him, so I sent it to the second known address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served, so I
I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess, after I sent the correct address and he got the document. He sent a letter that should be, I guess, in the file. He sent a letter, and
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury.
This part's gold. The plaintiff claims Richard committed perjury, as if lying on a dating app is a felony. Perjury isn't about fibbing during casual conversation. It's about lying under oath. The judge is trying hard to stay patient, but you can almost sense his disbelief. This moment highlights a bigger issue. Too many people walk into court without understanding how the law actually works. The courtroom isn't a feelings arena. It's about facts, evidence, and proper procedure. Still, the judge keeps a composure, even as this legal misunderstanding spirals out of control.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No. Do you understand what perjury is?
Yes, I understand perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly, and I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a
when did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court.
You don't understand, ma'am. You don't understand.
Are we done here?
Perjury is a false statement made under oath.
I know what perjury means. Are we done here?
You don't.
Is it a criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff. Wait a minute. You are the plaintiff.
Are we done here?
You have to lay out your allegations properly.
Are we done here?
No, we're not.
Exactly what perjury means.
No, we're not.
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your complaint out. You have to allege this in the complaint. You have not.
Do not insult my.
And here's where the confusion hits peak levels. Quant thinks that sending an email somehow amends her complaint. Nope. Courts don't run on Gmail. To add new claims, you've got to formally amend your complaint through the court clerk. Watching this exchange, it's clear she's way out of her depth, yet confident enough to argue with a judge. This is a classic example of why self-representation, or pro-Southeast litigation, can backfire spectacularly. Sometimes the more you talk, the deeper you dig your legal grave.
I don't think you understand what perjury is. It's a false statement made under oath.
Are we done here?
Please said
do not insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Are you going to dismiss it and refile it?
No, I'm not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
You can't
no, it
have
will
two
not be
cases on the,
dismissed.
ma'am, you can't have two cases going on the same issue.
Well, I'm not dismissing the case. If you want to
Well, I tell
dismiss
you
it,
what,
that's up to you. But I, as a plaintiff, am not dismissing the case.
he has to make a proper motion,
Well, that's on him.
but I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere.
When she insists that Richard's lies amount to perjury, the courtroom tension finally breaks into comedy. The judge patiently explains the difference. Again, but she refuses to listen. Richard, meanwhile, is sitting there, probably wondering how a bad date turned into a criminal accusation. This moment perfectly captures courtroom absurdity. A plaintiff convinced she's a legal expert, and a judge just trying to stop the madness. At this point, it's not a lawsuit. It's a masterclass in misunderstanding.
I'm going to do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that.
Forward.
That is not what I said.
Yes,
that is not what I said. I said that. No, I didn't. You
yes,
said
you
that.
did. You stated
I
that.
said that circuit.
You stated that the criminal. You stated that emotional infliction of emotional distress is, and you stated that perjury is a criminal offense. But you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the
even be
complaint.
on there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
Yes, you did.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said
so that's two
that
charges.
intentional. You need to be quiet while I'm talking. You need to be quiet. Can you mute her, please?
Because perjury is a criminal offense. It has to go to circuit court.
That will not make her hear you.
Intentional infliction of emotional distress.
This is where the gloves come off. The plaintiff starts talking over the judge, repeating, "Do not insult my intelligence," like a courtroom mantra. The irony? She's literally proving she doesn't understand the law she's arguing. The judge, remarkably calm, tries to guide her back to reason, but she's gone full courtroom Karen. The tension here isn't just legal, it's personal. You can see pride clashing with procedure, and ego clashing with logic. It's wild, uncomfortable, and hilarious all at once.
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters, because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court, because that's what you stated on the record.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Okay. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed. because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. And I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury.
By this point, the courtroom feels more like a reality show. The judge tries to explain jurisdiction, and she insists he said emotional distress was criminal. This is a classic telephone game, except with legal terms. The lesson here? Judges don't take kindly to being misquoted. It's not about emotion. It's about precision. And instead of clarity, we're watching complete confusion unfold. The back and forth shows just how quickly a simple misunderstanding can spiral when one side refuses to listen.
No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what
All
cost
right,
am I
that'll-
paying? Hold on. What cost am I?
Filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple
Because
cases
you
that have been
filed
brought
it in this,
forth.
because you filed it in district court. We don't do intentional infliction of emotional distress cases.
Well, I need to see that document in writing that states that
If you want
got
to
that
appeal,
district
if
court.
you want to, if you want to,
I've already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there
I'm
that
sure
states.
that you are. But
Yes,
if
I
you
am.
want, if you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling.
And that, folks, is how a $10,000 emotional distress claim turns into a full-blown courtroom circus. The judge stayed professional, Richard stayed stunned, and our plaintiff, well, she stayed defiant. This case proves one thing. Confidence without knowledge can be a dangerous mix, especially in front of a judge. So, what do you think? Was Quant genuinely hurt or just looking for payback? Drop your thoughts in the comments below. And if you enjoyed this wild breakdown, smash that like button, share this video, and don't forget to subscribe for more unbelievable courtroom moments and expert commentary.